Good afternoon, everyone. Thanks for coming to the webinar again. If we have some new attendees, welcome. So we have a bit of a special edition today. We did send out an email last week that some of you may have seen that we're going to cover the Clean Slate Act today in its entirety. So rather than our typical format of several shorter presentations, we're going to do one long presentation today, which will be a conversation between Laura and I. So let me introduce to you our speaker, Laura Harshbarger. She is labor and employment attorney here in the Syracuse office, a partner here. She's actually the chair of our labor practice and a friend and a mentor. So happy to be here today with you, Laura. I think this is going to be a good conversation. We had attendees request this topic, and so that's a reminder to all of you that we want to know what you want to hear about. So send us those suggestions, and we will keep doing our best to try to bring you content that you find relevant and interesting. And so that's what we're going to do today. Not sure if it's going to take the whole 45 minutes, but we'll see. Want to remind you about the Q&A function that's here in Zoom. I will be watching that. We can use that to contribute to the discussion. If I don't get to it right away, it might mean that it's already lined up to come later in the presentation, but do use the Q&A function. So with that, let me just set the stage a little bit for our discussion today. So the Clean Slate Act is actually set to go into effect very soon, November 16th, 2024. So that is just in a few weeks from now. And so I'm sure that's why we've had some of you asking us, hey, what's going on? What do we need to do? We got a law starting, going into effect soon. It is a law that seals criminal convictions of incarcerated individuals or convicted individuals after a certain amount of time. We're going to get into those details. But the idea behind this law is that for many, many years, it has been unlawful to discriminate against someone based on a conviction unless you could show a connection to the job. Right. So we have a law in place that Laura's going to talk about that says you got to consider lots of factors and then ultimately decide if the conviction really should prohibit a person from being employed with your organization. I think what the legislature determined is that law wasn't enough, that over the years, despite those protections, there's a feeling that individuals who have had a conviction in their past are still experiencing insurmountable barriers to the workplace. And so this law is designed to give them a clean slate, hence the name. And so that's really the background behind the law. So why don't we just get into the details of what this is all about. So I said that there will be convictions that are sealed, meaning you don't see them, it's like they never happened. Kathy, if you could keep going with the slides, that would be great. So the first question, I guess, is, well, what is being sealed? So Laura, could you tell us? I imagine it's not every law or every conviction that's being sealed. How is this going to work?
Yeah, absolutely. Good afternoon, everyone. Well, as Kristen said, this law is the next step in a progression in New York State toward encouraging the re-employment of individuals who have had convictions. The public policy behind that is kind of clear. It is if individuals with a conviction cannot obtain lawful employment, we have, as a society, condemned them to a life of crime, right? So this is a New York State initiative. It's a New York State prerogative. It's not necessarily the same in all of the jurisdictions across the US. We should be clear about that. We are talking about a New York State law. There are other states that are very, much in step with New York State. And then there are other states where these same protections do not apply, as in no protection at all for someone who has been convicted of a crime in the past. So if you're an employer with multi-jurisdictional operations, you're going to want to be cognizant of what is controlling in your particular jurisdiction. But we'll go ahead to the next slide, Kathy, on this. So to answer the question, when this law goes into effect, and we're going to talk about that, but the law is in effect as of November 16th, what is it applying to? It's applying to misdemeanors, it's applying to DWAI infractions and felonies, but this is subject to certain exceptions that we're going to go through next. So Kathy, if you'll go ahead and go to that. Okay, how is this going to work? So if someone is convicted of a misdemeanor, or a DWAI or a felony, there's going to be a particular waiting period before that conviction is eligible to be sealed. So for misdemeanors, it would be 3 years, DWAI, 3 years, felonies, 8 years. The law refers to this as a waiting period, and the waiting period is clocked, starts running from the time that the person is released from incarceration or from the time that they're sentenced, if this is a crime that did not involve any incarceration. So that starts the running of the 3 years or the 8 years. A person cannot have their conviction sealed if they are still on probation or parole or under any kind of post-release supervision. That would kind of, add to that time period, add to the clocking. What happens? It's a waiting period. The idea, the person has to have, keep themselves out of trouble before they are eligible to have a clean slate. If this is someone who is a repeat offender, they're not going to be eligible for a clean slate. So what happens in the event of a new charge or a new conviction? So if they are convicted again within the waiting period, so they don't get to the full 3 years that they had to be crime-free, conviction-free, that restarts, that new conviction will restart the running of the 3-year period. And if they are convicted again after a conviction was sealed, then that previously sealed record stays sealed. So let's think about how this might look. Let's say someone had a misdemeanor. We do misdemeanor, we're looking at a 3-year clock. They had a misdemeanor conviction in 2020. In 2024, they have gone the 3 years, and let's assume that's 3 years since the date of they were released from jail or there was no jail time. So that conviction is now eligible in 2024 when this law goes into effect. It's eligible for sealing. And let's now say it ends up being sealed. We're just going to pick next year. We're going to talk about a little bit of the mechanics of how the sealing is going to happen, but let's say it happens next year in 2025. If the person is convicted again of something in 2026, that previous conviction stays sealed. If, however, the conviction was in 2020, we're waiting for this law to go into effect in 2024. So hasn't been sealed yet, and they were convicted again of a crime in 2023. Well, now that conviction in 2020 isn't eligible for sealing because the 2023 conviction has reset the clock. You're on mute, Kristen.
I'm on mute. I should know that by now not to do that. So the next question is, are there convictions that are so significant or serious that they will not be sealed, that we will be continuing to see these?
Yes. So part of what New York State said it was attempting to do in crafting this law was to strike a balance, between some offenses that are so significant they really should not be eligible for a time period in which they receive no consideration at all. As against, again, that strong public policy toward ensuring that people have an equal, fair chance to become reemployed. There are certain convictions that will not be sealed. One of them is all out-of-state convictions. So the convictions that are eligible for sealing here are convictions that occur within New York State. Federal convictions, same thing. Those are not eligible for sealing. Sex offenses, as that's defined with the Sex Offender Registry Act. So a person who is required to register as a sex offender, that underlying crime is not going to be eligible for sealing. And then certain very serious felonies, your murder, arson, terrorism, there's some very significant violent crimes that will not be eligible for sealing, but others will be. So there are any number of violent offenses that are not so significant to be a Class A felony, and those lesser but yet violent crimes will be eligible for sealing.
Great. So, the question and answer screen is exploding with questions, which is what I was hoping for. So thanks everyone for trying to make this interactive. You're right on, luckily we've got plans to cover all these things. One of the questions was, do they have to apply for it to be sealed? And a different way of asking that question is, how does the sealing work? I've been wondering that same thing. When you think about it, there's this vast network of courts and prisons and agencies that have this data. How in the heck is this going to work where these are all magically sealed at the right time? And by the way, do we as employers have to do anything? That's an important question.
Right. Yeah. Well, I think New York State is wondering the same thing. How exactly does this get pulled off? Because you can only imagine the number of people and the number of records, because this is going back into time, right, immemorial, into perpetuity. Okay, so next slide, Kathy. Let's talk about how this works. First, I just want to remind everybody kind of what sealing is, right? It's a term that we're very used to in the law and as lawyers, but let's understand what it means. Sealing a record means that when someone inquires about it to the court or someone tries to look it up, you can't see it. It doesn't mean it's been expunged. It doesn't mean it has gone away. It just means it's being hidden from our eyes. That's what sealing means. The law says that the sealing is the sealing of records that are eligible to be sealed. So someone who has satisfied the waiting period and right now their crimes are eligible to be sealed is going to be automatic, which certainly sounds like, come midnight on November 16th, after the day this law goes into effect, presto, change-o, and it's all been done. It's all been sealed. In point of fact, what's going to happen is the law expressly, this is going to be so complex and this is going to be so complicated for the court system to make its way through, that the law gives the court system 3 years to do this. 3 years to even create the systems that are going to be necessary to implement this law. Because think about what has to happen. You've got to have databases that can reach out with tentacles and touch all the other criminal databases in all the other states and the federal system to know if someone in fact has been trouble-free for their waiting period. And then their parole period, right? And any supervised period of release. And then you've got to go through the process of, weeding those out and making sure that the records in fact do get appropriately sealed in the system. So while the law has gone into effect as of November 16, it will go into effect, it may be a couple of years before we are actually seeing these records start to become sealed, and that is after the unified court system has built out the computer programming that's going to, and any manpower that's going to be necessary to make this happen.
Right. So a couple questions of things we've already covered, Laura. So one is, we mentioned DWAI, an infraction there, and that's something that would normally show up on a driving abstract. And so the question was asked, will that still appear on a driving abstract? I mean, I would think the answer is not after it's sealed, right?
I would think that is the same answer, and that becomes part of the complexity of what needs to be put into place in order to know what becomes eligible and what isn't eligible to be sealed.
And another person commented that their insurance carrier requires them not to hire individuals with the DWAI on their record within the last 5 years. And how do they navigate that? I think that your insurance carrier is going to have to change their process. This sealing concept applies not just to the employment framework, but also to the licensing and other types of things like insurance. So the world will have to change to be consistent with that 3-year rule for DWAIs, I would think.
Yeah, absolutely. I mean, the answer is going to be that we won't have access to those records. And not only will we not have access to the records, but there will certainly be this, this notion that we shouldn't be requiring people to disclose things that have been sealed. There's a reason they're sealed. Sealing means they cannot be taken into account and into consideration. So I agree with you. I think what's going to happen is insurance policies and are going to have to catch up.
Yeah, and a couple questions about the sealing process again, about whether people can try to initiate or speed this up, their records getting sealed. I was wondering the same thing. I think what I saw is there's going to be a form that can be completed to request sealing. That form's not available. In fact, the form won't be out probably until 3 years from now, frankly. So it's not like someone can get ahead of the game and request that they get to the front of the line in sealing. Is that your understanding as well, Laura?
Certainly my understanding. I think in the interest of full transparency and full disclosure, I think a lot of this does remain to be seen, but that's certainly the way that you and I are both reading that idea of the form, that once all these systems are in place, someone may say, hey, I was missed, right? My conviction should have been sealed. It's not sealed. How do I get that fixed? And certainly there will be a manual process. It's clear there'll be some manual way to request review, but that's not the way it's going to be at the outset.
Yeah, and so another question that we have here is, so when I request a background check, these just won't show up? The answer is yeah.
Correct.
In 3 years, and we're going to get into what you should do in the next 3 years when it might show up otherwise, which is actually well, maybe I was going to say that's a good segue to the next question, but maybe not. Maybe we're not there yet. But let's go to the next question nonetheless. And I promise all of you, I see all your questions, and I promise there's a lot of themes in there, and I promise we're going to get to them. So anyway, but for now, we're going to talk about whether we should still be asking people if they have been convicted of a crime. Is that just so taboo now against public policy? Should we just not ask the question? What do you think, Laura?
Yeah, there's nothing wrong with this. We can still do background checks. We can still ask people if they have been convicted of crimes, subject to certain things, which we're going to talk about, in a minute. But this law does not erase the concept of considering criminal background history as being relevant to someone's suitability for employment. What it does is it says there's going to be a certain period of time that convictions almost burn off. They burn off, and those shouldn't be considered. So we won't see those, but those which are not sealed, certainly fair to take into account. So a couple of things here. We talked about this. There's going to be this, period of time, right? When, and we'll talk about that in a minute. This kind of awkward period of time. But once a conviction has been sealed, or once we're a little down the road, the person can truthfully answer no. And by the way, we should say there are reasons now why convictions might get sealed. And that includes things like youthful offender status. And those are treated now as if they never occurred. Not only can we not ask about, a sealed conviction or kind of something that's been sealed as youthful offender status, the person has no obligation under the law to ever disclose that. So what happens in this, in this time period? Because once a conviction is sealed, again, presumably the person isn't going to be disclosing it anymore. But what's happening between now and then? This is going to be the awkward time. Presumably, people will be applying for employment, and they may have heard about this Clean Slate Act, and they may be believing that their conviction is sealed. And because they heard it was automatic. So they may be saying no. If asked for, have you been convicted? Let's say they had a misdemeanor 2 years ago. That's a bad example. 4 years ago, they had their misdemeanor 4 years ago. And so in my 2020 example, right, that 2020 misdemeanor, that person applies, says, no, I don't have, because they're thinking it's sealed. In point of fact, it may come back on your conviction sheet, right? Now, has the person lied to you? I'd probably make an argument that maybe they haven't, because they were under a misimpression given the confusion of this law, that's something you'll have to work out with people. But the point is this: you will be seeing convictions on a background check that, once the court gets around to sealing it, will be sealed. And also this, until the court gets around to sealing it, it's not sealed. So you haven't done something wrong in having a background check where that conviction appears. It's not you haven't done something wrong that the background check company delivered it to you. You haven't done something wrong by seeing it, but you should anticipate that in the future you're not going to see that. And the individual applying may have believed that was going to be sealed. Also be aware, right, there are ban the box jurisdictions. We're not going to kind of get it, just a reminder, know what jurisdiction you are in. There are some jurisdictions that do not allow an employer to ask about criminal convictions prior to some certain period of time on an application, until a conditional job offer has been made.
Yeah, I think next slide, Kathy.
Yeah. And just showing you an example of such a law. So New York City Fair Chance Act, this is one example of a local jurisdiction having a more protective law around an employer taking into consideration or asking about criminal convictions. This is not terribly unusual. Again, other jurisdictions have these kinds of laws. Other states have these kinds of laws. In New York City, be aware, you can only ask about a criminal conviction after you have made a conditional job offer. So after you have decided that the individual in fact meets all of your qualifications for employment and you'd really like to hire this person, subject to a background check. That's the first time that you can have a background check, a criminal background check on the individual. The law imposes certain requirements on what you can say and not say in job postings. So we can't say no felonies, something like no felonies. Can't say, a background check required. There can't be any kind of, indication of that. And then in the event the employer is looking to take adverse action, meaning not hire or fire someone based on a crime, there's an analysis that needs to be done. The individual needs to be provided with that analysis. You have to give the person at least 5 days to respond before you can go ahead and take that adverse action. There are exceptions, but again, we're just noting that law enforcement and certain safety type positions to whom the Fair Chance Act is not going to apply. But we're really just raising for you here the idea that there are additional local laws to be aware of.
Great. I'm going to try to hit a couple of questions that relate back to things we already talked about before we move on. Couple of people commented about DWAI versus DWI, DUI. I'll answer that one, which is to say the reason DWAI is separated out is because that is neither a misdemeanor nor a felony. It's a traffic infraction. So that's specified as being sealed because it's not captured under the other two categories. But a DUI, a DWI would be sealed because it is a felony or a misdemeanor. So that's why we mentioned that very specific driving issue. The other thing that was asked is, just to clarify, what we're saying is that they're gonna go back forever in time and seal all the old stuff. And the answer is yes. That's why they've got 3 years to figure it out. I mean, great, assuming that it meets the 3-year or 8-year rule, etc. This isn't just convictions that happen prospectively that get sealed. It's the old stuff, right, Laura?
Yes.
Okay. All right. So bear with me as I try to work through these questions. Let's move on to the next question we have here in the presentation, which is, we sort of touched on that a bit already. It's sort of implied in what we talked about. Can we still run a criminal background check?
Yep, absolutely. There is one modification that the Clean Slate Act imposes, though. So, and when we say, it's in effect as of November 16th, we just may not see the sealing happen. Note that this change is going to be in effect as of November 16th. So the Clean Slate Act says that when you run a background check on someone, you need to provide them with a copy of the background check, what the results were, along with a copy of Corrections Law 23A, which we're going to talk about in a minute. And that sets out the factors that are permissible to consider and must be weighed when deciding whether or not to deny someone employment based on a criminal conviction.
Next slide, Kathy.
So Article 23A. So again, this is a pre-existing law. Excuse me. I'm sure you're aware of it, been around for a very long time. When we are considering whether a conviction should disqualify someone from employment or from hiring, we need to consider these factors. They have to be weighed. We have to weigh that there's a public policy in favor of reemployment. We have to look at the specific job duties and responsibilities. Do they bear a relationship to the criminal act or not? How does the criminal act bear on someone's fitness to perform the duties? The seriousness of the conviction. The time that's elapsed. Did this happen a long time ago? Is this something that happened very recently? The age at the time of the offense. Is this something, kind of an indiscretion of youth and someone, has really shown more mature judgment later? Or is this someone who committed the crime as a mature adult? Any evidence of rehabilitation, and rehabilitation there means a certificate of relief from disabilities, which means that the supervising correctional system has said that the individual has done everything they need to do to kind of fully re-enter society. That's to be given quite a bit of weight. And then we also are allowed, permitted to weigh as employers that the employer is going to have property concerns, safety concerns for individuals, and that kind of thing. I should point out that New York State does, at least the Division of Human Rights, does presume that this is going to be in writing. The analysis that the employer does will be in writing. And there have been instances where the State Division has said, if you don't do this analysis in writing at the time you are making the decision, then we're, from our point of view, it didn't happen. So it is important to do that in writing at the time. Additionally, Article 23A, again, existing law, tells us that if a person who has been convicted of a crime is denied the employment, is fired or is not hired, they are entitled to a written statement as to the reason for the denial, even if the employer is saying the criminal conviction didn't have anything to do with it. It wasn't about that. It was about a lack of qualifications. Someone who has a criminal conviction in their history is due a statement in writing, if they request one, have to request it, as to why they were denied the employment.
Thanks, Laura. And someone just asked the question, are we saying that we have to provide a copy of the background check whether or not there's a conviction? And the answer is yes. So every time you now run a criminal background check, it should be a part of your process that you automatically give a copy of that to the applicant. Okay, next question. So this is really getting to the heart of it now, and a lot of people are asking about this. So what do we do with all those convictions that aren't sealed, that still show up? Those are going to be the federal crimes. Those are going to be the out-of-state crimes, and then of course the crimes that have not yet been sealed. So how do we analyze it? Is it different? Do we need
Yes, right. It's a great question, and we just went through Article 23A. Those are the factors that we need to continue to apply. We've been doing it for years. We're going to continue to do it exactly that same way. So 23A 8-factor test still applies. What we might plant as a seed, though, in everyone's minds is whether, as part of this Clean Slate Act, is New York State really communicating the strength of its belief around that public policy in favor of reemployment? We see the State Division of Human Rights, the court system, which are the venues where someone convicted of a crime, if they've been denied employment, can go to complain and get relief. Might we see them taking an even firmer stand about the importance of that factor, the factor of getting people reemployed, and therefore, requiring a, kind of a stricter test before employment is denied.
Okay, great. So I think we're on to the next slide, Kathy. Yeah. Just wanted to touch on something here. Getting a couple questions about it in a background check. How far back can you go? I don't think anything changes there. A background check is a background check, and your vendor is going to go back as far as they find anything. That hasn't changed. What changed is what will show up on a background check.
Right, and usually it's 7 years but there are all kinds of, background check records that you see that go back farther than that. But again, that's not necessarily anything I think that we as employers need to worry about. We shouldn't see any changes there.
All right, so I think we touched on this, but what about convictions that are technically eligible for sealing according to the law now, because it's a 10-year-old felony and the person has really cleaned up, hasn't been reconvicted? How do we look at that for the next 3 years?
So here's a thought, right, on this, and let's take what we're saying, but back to my example of a conviction in 2020. It's now 2024. This law is going to go into effect, and it's not going to be sealed in the near term. So someone shows up applying for a job at your workplace, and it's 2025, right? And that should be sealed. Well, we know that that's actually not the case, that it hasn't been sealed yet. And so it can technically be considered because it's not sealed. But I think we should think about it through this lens. What New York State has just said by passing this Clean Slate Act is that in a couple of days, a couple of weeks, a year or so, we, New York State, think that conviction is so utterly irrelevant, we're not even going to let you see it. So we may be in a tough spot as employers if we are relying on a conviction that, at least by all appearances, probably really is eligible to be sealed, is going to be sealed in just a little bit of time. Because what New York State has said is that when someone is clean for 3 years or 8 years, we're not even going to let you know about it. It won't even be in your zone to take into consideration. So I think an employer could be in a tougher spot relying solely on that conviction that may be eligible for sealing. But again, recall, you don't really know, do you, as an employer? Because you don't really know if someone has kept themselves out of trouble. And yes, you're seeing what you're seeing in the background check, but that's the whole point of the court system's process. The court system's process is going to figure out whether or not that conviction truly is eligible for sealing.
Also, on the report, you're only going to see the conviction date. You're not going to know if they were incarcerated, when they were released, if they're on parole, if they're on probation. That's the triggering date. And so it's not just, if you see a conviction that's 10 years old, doesn't mean that it would necessarily be sealed. So it's a lot to put on employers to expect them in the next 3 years to do this analysis and figure it out themselves. I think be cautious in the next 3 years. But it's not an automatic rule by any means.
Right. And I think that's why we would say it's not on us, because the conviction is not sealed. Right. Mm-hmm. It appeared on the background check. The conviction is not sealed, but do think about it in the larger context of this law and the way this law is designed to operate. So you're going to look at things very holistically, the background check holistically, the job holistically, everything holistically.
Yeah, and the next question is very similar, Laura, so probably doesn't take much time, but just wanted to point out, what about those federal convictions, state convictions? I think we touched on this. You're going to continue to see those. I think it's just really what you've said, which is do your Article 23 analysis, but maybe the public policy piece weighs a little more heavily on the older convictions. Do you agree?
That's right.
Okay. I want to get to the next thing because there's been so many questions about this. I know we have a lot of employers out there in the healthcare industry and the nursing home industry. There's lots of industries that require background checks. Is it different for those industries? Can we talk about that, the special rules?
It is different. It is different. So for industries or positions that are subject by law to where a background check must be conducted. So there's a law that is saying that a background check must be conducted. Then you will continue to see those convictions. They will not be sealed for you. So when a background check is required by law, school districts, nursing homes, right, home health aides, financial industry, or some jobs in those areas, there may be fingerprint-based legally required background checks. And the fingerprint, think of it like a key. It's going to be the key to unlock those convictions that otherwise are sealed. So someone may go to apply for a job with a school district, and they're going to have one background check that comes back. They go to apply for a job at a retail store, and they have a more limited background check because the retail store isn't going to see the convictions that were sealed, but the school district is.
Yeah, it's really a different process, right? So if you're in those industries, you already know that you're running a different process that involves fingerprints, that involves the state government, the DCJS that actually, works with you to provide that data. You're still going to see, those industries are still going to see those older convictions if it's coming from the fingerprint-based background check. The next question is, how do I know if that's me? I think hopefully you kind of already know that, but we wanted to address it a little bit here. Laura, can you talk about it?
Yeah, sure. Just next slide. Yeah, Kathy. Well, kind of pointing out here that these are the background check. I'm sorry, the fingerprint initiated background checks. Can probably even go on to the next slide, Kathy, just to kind of move along. And so these are the industries where generally you see those kinds of requirements. Next slide.
Negligent hiring liability. So this has come up in our Q&A as well. And I'm doing my best, everyone. I have 50 unanswered questions, so I'm just trying to get through them. What happens if there's so someone has a conviction from 15 years ago that if I looked at it now, it would be directly relevant and I probably wouldn't have hired the guy, but I hired the person because I didn't know about it. Does that come back on me?
It doesn't. So the Clean Slate Act makes that very clear that when a conviction is sealed, the employer never had any chance to know about it. So if you didn't know about it, you can't be negligent for not knowing about it, right? So the law has that covered for us.
Next slide. Any other laws that we need to be aware of, Laura? Any reminders of existing laws about background checks?
Yeah, so just super quickly, do recall that we have a federal interplay here, right? So the Fair Credit Reporting Act, a federal law, applies to consumer reports, which include things like running a criminal background check on someone. There's also something called an investigative consumer report, not done very often, but that's kind of a more interview-based background checks. This doesn't apply to internal checking within the employer about someone. It doesn't apply when the employer themselves picks up the phone and asks for a reference for a previous employer. The Fair Credit Reporting Act applies when there is a quote unquote consumer reporting agency. So some third party vendor or business that the employer is going to run the background check. A consumer reporting agency is an entity whose business is running background checks. Next slide. So just really quickly, just reminding everybody, you've got to give folks notice under the Fair Credit Reporting Act, written notice that you're going to be running a background check. That disclosure has to be a standalone document. You can only combine it with the actual authorization that the employee signs to allow for the background check. And then you need to certify to the consumer reporting agency that you have complied with these steps. There are more rules for investigative consumer reports. If you think you might be doing some interview-based background check, you'll reach out to counsel because there are more requirements, but we won't get into those now. Next slide. So before you take adverse action under the Fair Credit Reporting Act, this has been the law, right? You provide a copy of the report. Here's the background check that I received. Here's what's troubling me. Providing a summary of your rights under the Fair Credit Reporting Act, and then allowing them a reasonable period of time to challenge the report, which is really to say, hey, look, if they have something wrong here, this shouldn't be on my report. That's the opportunity that's being given. So recall though that the Clean Slate Act kind of may change that first bullet, because here the Clean Slate Act is telling us that whenever we're running a background check, we are providing a copy of that report. So that step will largely already have been taken care of. Next step. Then after you decide not to hire someone, you need to notify the applicant that is what happened. You don't necessarily have to give you all your reasons. You don't have to give your whole analysis unless you're down in New York City under the Fair Chance Act, but you do have to explain that it was this was the report, and that this is the name of the credit reporting agency if the individual would like to contest that report. And then you're reminding everyone that Article 23A requires the written statement of denial upon request from the applicant. Any couple of things, Kristen, that we didn't touch on?
Yeah, I'm trying to sort through here. One thing that we didn't touch on is people are asking whether we would recommend on an application, if they're still going to ask for criminal convictions, if they should add, do not report anything that is sealed or something like that, kind of a heads up to the candidate.
So, I think we don't have to say, you should check no if your conviction has been sealed. But I think it's not a bad idea, because the fact of the matter is something that has been sealed need not be reported, and we shouldn't be requesting it. So clarity in what it is we are asking the applicant to disclose never seems like a bad idea.
Yeah. I'll just try to randomly pick a few. We've got a couple more minutes here. Domestic violence crimes, will those be sealed?
There was no exception.
There was no exception for domestic violence.
Not as a category. I mean, certainly some domestic violence offenses could, end someone up in a category, either a felony or a sex offender registry, but not as a category.
Yeah. Someone asked if the background check company will take care of sending a copy to the applicant, and that's something that crossed my mind. I would check with your vendor, because it's possible that could be built into the process to take that off your plate. So that's a good question. And let's see here, a couple more questions here. There's so many. We will take a look at these and try to follow up. These are all really great questions. Just shows that there's just so much to learn about this new law, for sure. A lot of the questions are kind of about the timing of the sealing. And the good news is you don't really need to worry about it. I know it's interesting and you want to know, but you don't have to do the sealing. So it's really just knowing that there's going to be a category of convictions that, based on state policy, the court system is going to take care of removing those from people's records, and it just will be as if you don't know, that as if it never happened. So yeah, it's definitely a complicated area in some ways. In other ways it's not, because you don't have to take care of that. So any final thoughts, Laura? I don't want to keep people late today despite all the questions.
No, I think we should let everyone go. I mean, the major takeaway here is that yes, this law is in effect. Yes, you need to be aware of it. We are not going to see the significant impact of this for a couple of years, probably, until those systems get built. And in the meantime, we're going to be in this, murky gray area. Be aware that applicants may be confused about whether or not their convictions have been sealed, and they would be, forgiven at some level for being confused, because this is an unclear rollout And it is a rollout that is going to take some time. And we all ought to think about kind of where the public policy of New York is heading on this, and build that into our hiring considerations.
Yeah, and I'm going to offer one final thought because I just saw it and I think it's key. If you ask a person, have you been convicted? And if their conviction has been sealed, they can and should truthfully answer no.
Correct.
I think that's a very important closing thought to keep in mind.
Right. They have not lied. A conviction that is sealed, they by law can and should answer no. And we should not be expecting or asking anyone if they have sealed convictions. They're
Correct.
sealed. They're by law, we cannot ask about them.
Correct. Okay, great. A lot of good information. This was fun, Laura. I kind of like this format. So thanks everyone for being here, and see you again in a couple weeks. Take care.